Welcome to The Market That Moves America, a podcast from the National Center for the Middle Market. The center is the leading source of knowledge, leadership, and innovative research on the middle market economy. Throughout our podcast, we will feature middle market leaders and stakeholders to hear their real-world perspectives on trends and emerging issues.
In a previous Market That Moves America episode, we talked about the importance of intellectual property in the middle market. In this episode, we're going to explore more deeply the concept of hidden IP, intellectual property that may not be readily identifiable to a lot of middle-sized companies, but is just as important to think about and protect. Joining me will be two members of the team at Harness IP, an NCMM member company. Welcome to the Market That Moves America. My name is Doug Farron, Managing Director for the National Center for the Middle Market, located at the Ohio State University Fisher College of Business. Middle market companies may not consider intellectual property as a significant issue, challenge, or opportunity. And we are glad to welcome back one of our member companies, Harness IP, and two of their leaders to talk to us today about some of the opportunities that lie around hidden intellectual property within their companies. Joining me today are Brian Wheelock and Joe Walsh from Harness IP. Welcome.
Thanks, Doug.
Yeah, thanks, Doug.
So we had a conversation, months back, I think maybe in 2023, where we introduced Harness. We talked about the idea of intellectual property, maybe at a higher level. So excited to kind of revisit this topic and dig a little bit deeper into this concept of what you mean by hidden IP and how middle market companies need to think about it and address it. Before we get into some of those topics, could you both just, again, for our audience, tell us a little bit about yourselves, your background, and your current roles and responsibilities?
Sure thing. Why don't you start, Brian?
Okay, well, I'm a mechanical engineer by training and then, of course, on to law school. And I've been practicing solely in the area of intellectual property for the last 42 years. And for the last 20 of those, I've been teaching intellectual property at Washington University Law School here in St. Louis.
And this is Joe Walsh. My background is chemistry, also a lawyer, patent lawyer, trademark lawyer, copyright lawyer, trade secret lawyer. And because I've been very fortunate to have multinational clients throughout my career, I've worked in virtually every industrialized country throughout the world dealing with these intellectual property issues. I've got 6 years less experience than Mr. Wheelock. I've been at it for 36 years now, I guess. Or no, 38 years. And 21 years ago, Brian and I founded the St. Louis office for Harness IP, which is one of the nation's oldest and most venerable intellectual property boutique firms. We just celebrated our 103rd anniversary, and Brian and I started the St. Louis office a little over 21 years ago. So all we do is intellectual property, which is traditionally regarded as patents, trademarks, copyrights, trade secrets, related litigation, and licensing, and we do it everywhere throughout the world.
Excellent. Yeah, so I'm truly am talking to the experts in this space. So as I mentioned, our last conversation, we focused a lot on some of the things that you just named, copyrights, names and trademarks, and so forth. So you mentioned your firm focuses only on these issues, intellectual property, and have a lot of middle market clients. Can you talk to us about what you see as some of the potential for these companies around intellectual property?
Well, I think that, our topic, today was kind of focusing on this hidden IP because every business has intellectual property, kind of whether they know it or not. And so we're talking about the things like brands, names for products that no one ever bothered to formalize, but probably should have. Even shapes and color schemes for products and packaging, that type of thing. The know-how to do things that confidential information that is very valuable, but no one has bothered to document or formally protect. And then a big area is copyright, which we did talk about the last time, but there are a lot of things that a business does that are copyrightable. And copyright is really the most business-friendly kind of IP because it really doesn't cost anything to get copyright. So it's those types of things that the business is using, and for one reason or another, they never got around to documenting or protecting.
Yeah. What is it? What do you refer to when you say hidden? Does that mean that it's just not maybe obvious or apparent or easily thought of when you think about hidden IP?
Exactly, Doug. It's not like it was intentionally or purposefully hidden. It's really just unrecognized or unappreciated intellectual property. And Brian kind of alluded to that. Intellectual property exists in every form of business that I can think of. And as Brian pointed out, it's things that you might not even consider intellectual property, like uniforms for your employees, for example. UPS is a good example. They have protected the color of the uniforms that their people wear. So when you see a UPS guy walking down the hall, he's got that particular Pantone shade of brown that it's called UPS brown. That and even if you see him from the back, if he's wearing shorts or she or long pants, that's a UPS person. There are restaurants that have protected the form of uniforms for their employees. So you may not even think about it, but it's the little things that enable you to compete, and you may take them for granted. So when we say hidden, we're not necessarily mean like stashed away or purposely put into a box. We're really referring to things that may not be obvious to you as protectable, but are forms of intellectual property.
That UPS example is a great one, particularly as we think about large companies. Do you feel that there's more of these hidden IP opportunities in the middle market, given the fact that they probably don't have, the same resources kind of thinking about and addressing these things?
Well, I don't know if, quantifiably there are more, but certainly they're less appreciated. And the obvious reason why is because major corporations have teams of people looking for, and identifying regularly what gives them their competitive advantage. Whereas, middle-sized companies and smaller businesses, they don't have the resources to focus that much on, those topics. So I don't know if in sheer number they are greater, but certainly they are greater as a class of assets that are less focused on and perhaps less appreciated.
Sure. So you mentioned some examples: brands, uniforms, color schemes, copyright maybe being the most business applicable. What are some of the other kind of forms of hidden IP that maybe you see most frequently in these mid-sized companies? Are there any particular categories that haven't been mentioned, or where do you see the predominance of these types of opportunities that may go unrecognized?
I think the first one would probably be copyright. Everything that the business creates is, any kind of written material, graphic material is copyrightable, but few businesses take the time to register the copyright, which confers very valuable benefits and isn't that difficult or expensive. But even business rarely even put copyright notice on it, which only costs you the time to put a C in the circle, the name of the company, and the year that the work was published. So the copyright is a big one, and it can have really big effects on keeping business and keeping competitors away from your business. And another one is trade secrets. Just the secret information. How our product? Why is your product better? Oh, we know this process. We heat a little more. We have a secret ingredient, and everyone kind of knows. Oh, keep that secret. But there's no formal protection. The employees haven't been instructed. They haven't signed a confidentiality agreement. Someone gets disgruntled and leaves, or and all of a sudden, other people have that information. So those are the two big ones. Everyone knows if there's a big invention, holy crap, Joe just solved this problem. They're going to think, well, we better find a patent lawyer someplace. But it's those types of things that I think go on overlooked.
And before this presentation, Brian and I were talking about this very topic, and The copyright, I'm going to go back to the copyright issue because, we consider copyright to be the biggest bang for your IP buck. And the reason is it's, copyrights come into existence automatically. You don't have to do anything, unlike, getting a patent on your invention or getting a trademark registration on your brand. A copyright comes into existence the moment the original work of authorship is fixed in a tangible medium of expression, which basically means if you put pen to paper and start writing something, the copyright exists. Now, in order to protect that copyright, you have to federally register it. If you want to sue somebody, based on whatever it is you've written or created, you have to get a registration. The registration cost is $65, at the Copyright Office. Now, most people don't know how to, file the application to do that. So we charge a few $100s. It's very inexpensive to our clients to go ahead and get the copyright registration. But once you get that registration, let's say, for example, you create a user manual for one of your products. All of that is handwritten. It's the result of an employee's original thoughts and formatting it, laying it all out. It's very very definitely copyrightable. Let's say that a competitor wants to figure out a user manual for their competing product. It works basically the same way yours does, and they just copy your user manual. Well, they've infringed your copyright. But if you have a registration in existence before they infringe, you get access to statutory damages. And I think maybe in the last program we talked about damages being the most difficult thing in any lawsuit. I don't care if it's a dog bite case or a real estate transaction or a medical malpractice case. Proving damages is the most difficult thing to do. Here with a copyright case, if you have the registration before the infringement happens, you get a statute that shows you what your range of damages are. And you just have to argue to the judge that you're entitled to, the maximum amount that you want to get. And if you win the case, if it goes to a decision, you get your attorney's fees back. There's no question whether you get your attorney's fees. They have to be reasonable, and the judge has to, establish that they're reasonable, but you get your attorney's fees. So that's what I mean by the biggest bang for your buck. Anything that you create, packaging for, your products that you send it in, if it's fanciful, if it has some interesting logos or designs on it, you can register the copyright in that. Your website, you should be registering the copyright in your website content, all of it. It's all been now. There's an interesting point there too, because if you hire a consultant to develop the content for your website, the consultant is the author and the owner of the copyright unless you get an assignment from them. So you need to make sure they have an agreement with all of your outside vendors who are contributing, to your website and to your packaging and your materials and all that. You need to get assignments of those copyrights, but they're usually more than willing to do it, in exchange for the work. It's a lot easier to get it up front too than it is later, after the work is created and you've already paid for it. So these are some of the issues we're talking about. When we go back to hidden IP, it's not so much like it's stored up in a box. It's stuff that's unappreciated, and you didn't really take the time to figure it out. And if you're at a point where you've got a problem, a dispute has arisen, if you haven't thought about this stuff in advance, oftentimes it's going to cost you a lot more money to figure it out than it would have if you had taken the appropriate steps early on. And I think that's pretty much a maxim that applies universally in life.
Yep.
Yeah. Yep. Are there other risk exposures by not going through that copywriting process? So, clearly having your stuff plagiarized or, copied by a competitor damages. What other exposures does that create if you don't do the diligence of registering?
If you don't register, if you don't get the registration promptly, then it isn't proof of your ownership. So you need to get a registration promptly for that and to get those benefits. And you want that registration before the infringement begins, as Joe explained, because you're not going to get the most damages. But you don't want other people claiming that material is theirs. The consultants Joe mentioned, if the agreement says the business owns the work product, but they go and register it, there's complications. So it's always better to take the time and do things properly up front. But in the exigencies of business, that doesn't always happen.
But with copyright, it's pretty straightforward. If you go through one exercise with us or another IP lawyer involving a copyright matter, you're going to know how to deal with that every future time it comes up.
Yeah. Do you, obviously, I'm not looking for specific names and so forth, but can you share any other examples of maybe middle market clients that you've worked with where you've had, I don't know, maybe it's copyright, maybe it's even like a trade secret that wasn't, properly managed, and there was an issue that arose. Do you have any, like a case example or a?
Yeah, I've got one for you, Doug.
Yeah, sure.
And it's not copyright. It's more patent involved. It's an invention. But we had a client several years ago, who manufactured welding products, and a big part of their revenue stream came from the tips that are expendable during the welding process. You have the torch, and then you have a tip that draws the bead on whatever the substrate is, and they made a lot of money selling replacement tips. Well, they wound up having a lot of foreign competition for these expendable tips, and the foreign competitors were pricing them lower and beating them in the marketplace. So they saw their revenue stream for the replacement tips drop way off. Well, we decided to have a powwow with the client. We spent an afternoon with them, talking about where they make their money, where they're losing money, and all that. And this topic came up. And one of the suggestions we had after a couple hours of discussion was, hey, what if you reconfigured the way the tip fits to the welding device? Because they were an industry, they were one of the dominant players in the industry. So they weren't afraid of not selling their welding tools. But we said, what if you adapted the end of the welding tool so you had a specially configured replaceable tip that you could only use your tips, and then we'll patent that design. Well, it took a couple of years, but within 3 years, they saw so they took our advice, and then within 3 years, we saw their sales of these tips go way up, obviously, because if you bought the tool, you were going to be buying the replacement tips from them as well, because if you bought the foreign competitive product, it was an infringing product, and we went after those infringers and stopped them. So there's an example of how intellectual property helped, a medium-sized company restore lost revenue.
Yep. We touched on this a little earlier in the conversation today, but we say here at the center, oftentimes we use this phrase: middle market companies face large company problems with small company resources. We talked about that a little bit, but can both of you expand a little bit more on how you see that playing out in a typical mid-sized client who, they probably don't have an in-house counsel. They may only have, a handful of people in HR, communications, whoever's tasked with kind of managing things like IP.
Yeah, if you don't mind, I'll take this one too, or at least start off. I think as we're trying to impress upon everyone, all the listeners, intellectual property is vital, despite whether you have a large business or a small business or a medium-sized business. It's an integral part of what you do. And if you bury your head in the sand and refuse to acknowledge it, somehow you're going to wind up losing something. Sales, product lines, customers, whatever. You're going to lose something if you're not paying attention to intellectual property. Now, the one thing we have large multinational clients, and we meet with them literally monthly, if not biweekly, or bi-monthly, where we have these review discussions. We spend an hour talking about all the new innovations, things that have come up, figuring out ways to protect all this stuff. Medium-sized companies, smaller companies don't have the resources to do that. What they do have the resources to do, and what we actually make available to our clients, is we say, look, if you're not in our hometown, just pay our travel expenses and lodging expenses, and we'll spend a day with you for free, and we'll talk about your business and, where are you getting your revenue from? What trends have you seen with the revenue? What new products have you developed and put in the marketplace lately? What steps have you taken to protect these things? And we'll brainstorm like this, and it's a very cost-effective way to really get your arms around, what intellectual property you're not appreciating. And if you do that once, or better yet, twice a year, I think that's money well spent for a middle-sized company.
Yeah, that's exactly right. We kind of call those IP audits, and doing it on a periodic basis, having people who know IP come in and just point out the things that you think, oh, that's just the color of our package. No, that's your trade dress. Oh, that's just the copy on the instruction manual. No, that's your copyrighted, explanation. So doing an IP audit, doing a little bit of, as in conjunction with that, some employee training. Once employees are aware of it, everyone gets kind of excited. Oh, I invented this. Can this be patented? Or I've done this. Can we protect this somehow? So a little bit of employee training, getting people, in the habit of documenting what they've done on a periodic basis is good. And then, carefully pursuing the right legal protection. You don't have to protect everything, but you got to protect the things that confer a benefit to your business or would be, help your competitors compete against you if they could do.
And interlace with that are appropriate agreements with your employees too. And that's really the starting point. Every employee should have an employee agreement, which is different from an employment agreement. An employment agreement specifies a duration of time and a salary and what the expectations are. An employee agreement is still, pertains to at-will employees, but sets out the obligations and requirements that the employer has for the employee, like the requirement to assign all inventions that are developed, that pertain to the business. There's different ways to handle this, but if you don't have these agreements in place, this intellectual property is walking out the door and going to your competitors the moment this employee leaves. So making sure you have the right agreements, and then Article 1, Section 8 of our Constitution actually provides for patents and copyrights because our founding fathers knew that in order to advance the state of the art and to incentivize people to improve the quality of life and the standard of living and come up with inventions, you got to give them something. So we have clients that give thousands of dollars to their employees when they come up with something. We have other clients who give movie tickets or $25 Visa cards or whatever. So if innovation is even marginally important to your business, come up with some sort of little incentive program and make it fun because you're going to wind up getting a lot of information about your business that you may not even be aware of that's going on the manufacturing floor right now.
Yeah. Well, yeah, what I'm hearing is this needs to be implemented on at least an annual, if not more frequent basis, just like strategic planning, just like annual budgeting and all those other types of tools that are, just pretty good, straightforward, simple management. Reviewing IP needs to be embedded in that as well.
Yeah, we agree fully. Yep.
So, yeah, I guess just in closing, and I'll again have both of you kind of weigh in on this. So if we, for any middle market leaders that could be listening to this right now and thinking, my goodness, I've got a lot of opportunity here because I'm not doing these things, or I need to really go back and take a hard look and identify where I may be exposed or have some of these hidden IP opportunities. What would be your advice on next steps or how they should start this process? I mean, you talked about coming in and maybe leading a day-long conversation, but what other pieces of advice could you share with our listeners about how to start this process if they're not doing it already?
Well, before I get to that, I will get to that. I just want to address one point. There's probably a lot of people listening and think, the business is going okay. What is talking to a couple of smart, and as far as a podcast audience knows, good-looking, IP attorneys going to do for my business? And, I just think they ought to think about this. One, you have a competitive advantage from the stuff that you've created. IP helps you keep that advantage and stops your competitors from taking it from you. It also presents some unique monetization opportunities. So you're doing something well in one industry and your brand is pretty popular. There's related products, and people, boy, I'd love to sell our related product under that brand, so you can license the brand or license some of the materials you have. So licensing what you come up with. If you've documented your IP, you can do that. But also risk mitigation. it's a fluid workforce. People come, people go these days, and they go, they stop working for you and they go back to a competitor. Now your competitor knows how to do something or does it the same way. So it's that, mitigating your risk. And finally, the valuation. Your business is more valuable the more IP you have. So if you're going for financing, you're looking for investors, or at some point it's time to sell out, the amount of IP you have is almost always the biggest value of any transaction.
Yeah, these are balance sheet assets, and if you don't protect them, they're not, easily quantifiable. And in fact, if you're, going to take your business to market and try to sell it, one of the first questions a prospective buyer or their lawyers is going to ask is, show me what you've done to protect your intellectual property. And
Right.
if you come at them with a bunch of patents covering your primary inventions and trademark registrations and copyright registrations, they know they're getting some value.
And so to answer your question, how do you get started? Just start paying attention to inventions and to brands and to works of authorship and the secret and confidential information you have. There's no shortage of IP lawyers out there who would be happy to talk to a new client. As Joe said, we travel quite a bit and talk to clients, spend a day with them, just helping them find what they got. So call a friendly IP lawyer, someone that sounds like you could work with them, and get started. And the sooner you do it, the better the plan can be, and the greater you can spread out any cost that you may have to incur. So it's just, the way to get started is to get started. Call someone.
And I'll just add as a final point, just like in so many other areas of life, follow the money, follow the revenue, trace your revenue. Where's your revenue coming from? Is it protected? Where's your future revenue going to come from? Is that protected? It's all about sustaining the business. So knowing where the revenue is coming from and where it's likely to come from in the future are good ways to begin thinking about, have I done enough to protect that revenue source?
Yep. Well, these have been great insights, and as always, appreciate all the expert advice and just bringing a lot of attention to these topics, which again I think have the ability to be pretty easily overlooked in a busy mid-sized company that again doesn't have a ton of resources. So Brian, Joe, want to thank you again for joining me today and for all your time and expertise.
Hey, our pleasure, Doug. Anytime, and we enjoy doing these. So call us again.
Yeah, thanks for the opportunity.
Yeah, certainly. Thank you. For more about Harness IP, please visit their website, which is www.harnessip.com. Thank you.
Thank you for listening to The Market That Moves America. Never miss a new episode by subscribing anywhere podcasts can be found. You can also subscribe to our email newsletter at middlemarketcenter.org.